Hey, Tony DeWitt here, Missouri Appellate Attorney. I'm retired, and this is not legal advice. Everything I say is simply commenting on the law, and this will be what we're commenting on today. Well, I can't say that the Melody Farris conviction surprises me in any real way. There was really a great deal of circumstantial evidence that I think was very powerful with the jury. And one of the jurors appeared on court TV. Her name was Bethany, and she talked about the audio recordings being important, among other things. So I wanted to take a minute or two and talk, if I could, about that particular verdict and something about the Allen charge that I made reference to the other day. This was a strong circumstantial case, but the thing that I think really hit me after I listened to the juror was how great it is that we have juries to decide cases like this. Because I was really hamstrung with the idea that the prosecution had no evidence to support how he got out of the basement if he was indeed shot in the basement. And that seemed to be the theory. But one of my bosses used to say, none of us is as smart as all of us. And I think you get that effect with a jury because this juror, Bethany, on court TV, said that she thought maybe he was shot in the basement and wounded as he was, he climbed up the stairs and tried to get to a car to go get some help, and that he collapsed and died, and that Melanie then drug him to the burn pile. She said that that assertion, that reasonable inference from the evidence was one of the things that was powerful for her. And I think it would have been very powerful for me if I had been on the jury in this case. Now, what's interesting about that is the prosecution provided absolutely no evidence that he somehow climbed those stairs on his own after he'd been wounded. But it does make perfect sense. You will often see people who are wounded by gunfire run 10, 15, 20 yards down the line before they actually fall down and collapse. And even then, they'll continue to crawl. So it's not like being shot somehow just drops you over right at the moment. There are numerous instances in the police journals and other sorts of things where they talk about, you never turn your back on someone that's shot because they can still be a danger. That's why you'll see a lot of times when the police in their body cam videos, when they know the other person has a gun or a knife, they'll go up with a shield in the event that the person gets a second wind and essentially tries to overtake them. So again, I thought that kind of reasoning by the jury was really very good. But the long and short of it was that little lack of evidence about how she got up out of the basement was sort of trumped by all of the other evidence that tended to make up for that doubt and make that doubt seem less reasonable. There's a good chance that at least two jurors were involved in hanging up the jury. Now, I have to say that one of my commenters on here posted that I was just hypothecating without any evidence. And, that is sort of what I do. I mean, I'm not there in the jury room. I can't tell you what the jury's doing. And my job is to predict based on my experience what happened. And that's what I was doing. My concern going forward is with the Allen charge. Now, the Allen charge is that little instruction that the judge gave about go back and continue to deliberate.
You don't believe that you'll be able to come to a unanimous decision. I know that y'all are working hard. I know this was a long and complicated case. And here's what I have to say to y'all. When we talk about jury service, the phrase that comes up is the best and brightest. Y'all are the best and brightest of our community. Y'all have been selected to try this case. No one is more qualified than the 12 of you to make a decision in this case. In the instructions I gave you last week, you were instructed to reach a unanimous decision, and you should continue to deliberate and attempt to reach that conclusion. There is no set time for deliberations to cease. I'm going to instruct you to return back to the jury room and continue to deliberate until such time as you can reach a verdict.
In 2004, the Georgia Supreme Court held that the Allen charge in a pattern instruction was incorrect. The state has a book of pattern instructions that judges are supposed to give. And they determined that the Allen instruction charge in their pattern jury instructions was incorrect. They said that it was incorrect because it said that in that case, the case had to be decided by some jury selected in the manner that this jury was selected, and there is no reason to think a jury better qualified than you would be chosen. And the part of that they took umbrage in was the part about some jury selected in the same manner that you were selected. While they found fault with the instruction, they did not reverse the conviction, because what they concluded at the end of the day was that the Allen charge was not overly coercive. Given that the pattern instruction was not used, the actual text of the jury instruction given by the judge in this case was essentially something that he winged. He just made it up right there on the spot. He told them what he thought. And the problem with it is that he said that he wanted a unanimous verdict and that they were instructed in the jury instructions to deliver one. Well, I can see a judge on the Georgia Supreme Court saying that the requirement that the jury be unanimous without providing the guardrails of saying consider each other's opinions, keep an open mind, and make sure that you are firmly convinced. Don't just throw away your opinion on the basis of other people. You should be firmly convinced. You should definitely rely on your own judgment in that regard. Because he didn't provide those guardrails, I can see a court saying, it really did sound like you were sending them back and they'd be there until, they finished their homework. That, I think, could be considered to be somewhat coercive. And I want to point out that one of our commenters on the channel said that jurors perceive an Allen instruction as a get me a verdict or you'll stay here till you do kind of charge. Now, the Allen charge traces its roots back to Allen versus the United States, which was a case that was tried in 1896. It was a really odd opinion and a really odd case for the Supreme Court because the defendant did not even file a brief in that case. So I'm not sure how it even reached the United States Supreme Court, but it did. The court paraphrased the instructions as follows. These instructions were quite lengthy and were in substance that in a large proportion of cases, absolute certainty could not be expected. That although the verdict must be the verdict of each individual juror and not a mere acquiescence in the conclusion of his fellows, they should examine the questions submitted with candor and with a proper regard and deference to the opinions of each other, and that it was their duty to decide if they could conscientiously do so, that they should listen with a disposition to be convinced to each other's arguments, that if the much larger number were for conviction, a dissenting juror should consider whether his doubt was reasonable, and which one that made no impression upon the minds of so many men. Equally, on the other hand, the majority was for acquittal, and the minority ought to ask themselves whether they might not reasonably doubt the correctness of a judgment which was not concurred in by the majority. While it could be argued that such an instruction was unduly coercive, particularly in its direction only to dissenting jurors, the Supreme Court took just a little bit of time before strongly supporting the instruction. Here's what it said. While undoubtedly the verdict of the jury should represent the opinion of each individual juror, it by no means follows that opinions may not be changed by the conference in the jury room. The very object of the jury system is to secure unanimity by a comparison of views and by arguments among the jurors themselves. It certainly cannot be the law that each juror should not listen with deference to the arguments and with a distrust of his own judgment. If he finds a large majority of the jury taking a different view of the case from that which he does himself, it cannot be that each juror should go to the jury room with a blind determination that the verdict shall represent his opinion of the case at that moment, or that he should close his eyes to the arguments of men who are equally honest and intelligent as himself. So as a result, courts have been using a standardized Allen charge in lots of different cases throughout the United States. Although in a small minority of jurisdictions, they have done away with this, simply telling the jurors that they should go back and consider the thoughts and opinions of others and keep trying. But one of the things that I think is really important is that in some of the states, there are pattern jury instructions that are very much like this one from the Eighth Circuit Court of Appeals. This is what the Eighth Circuit says a trial judge should say to a jury that is deadlocked. As stated in my instructions, it is your duty to consult with one another and to deliberate with a view to reaching agreement if you can do so without violence to your individual judgment. Of course, you must not surrender your honest convictions as to the weight of the or effect of the evidence solely because of the opinions of other jurors or for the mere purpose of returning a verdict. Each of you must decide the case for yourself, but you should do so only after consideration of the evidence with your fellow jurors. In the course of your deliberations, you should not hesitate to re-examine your own views and to change your opinion if you're convinced it was wrong. To bring 12 minds to a unanimous result, you must examine the questions submitted to you openly and frankly, with proper regard for the opinions of others, and with a willingness to re-examine your own views. Remember, if in your individual judgment the evidence fails to establish guilt beyond a reasonable doubt, then the defendant should have your vote for a not guilty verdict. If all of you reach the same conclusion, then the verdict of the jury must not be not guilty. Of course, the opposite also applies. If, in your individual judgment, the evidence establishes guilt beyond a reasonable doubt, then your vote should be for a verdict of guilty, and if all of you reach that conclusion, then the verdict of the jury must be guilty. As I instructed you earlier, the burden is on the government to prove beyond a reasonable doubt every element of the crimes charged. Finally, remember that you are not partisans. You are judges, judges of the facts. Your sole interest is to seek the truth from the evidence. You are the judges of the credibility of the witnesses and the weight of the evidence. But you may conduct your deliberations as you choose. But I suggest that you carefully reconsider all the evidence bearing upon the questions before you. You may take all the time that you feel is necessary. There is no reason to think that another trial would be tried in a better way or that a more conscientious, impartial, or competent jury would be selected to hear it. Any future jury must be selected in the same manner and from the same source as you. If you should fail to agree on a verdict, the case is left open and must be disposed of at some later time. Now, please go back now and finish your deliberations in a manner consistent with your good judgment as reasonable persons. That's the Eighth Circuit charge. Those of you who saw and heard the judge's Allen charge know that it was not even close to this. But in most respects, this is all just a good way to teach on the subject of an Allen charge, because the defense did not object to the instruction. As a result, any appeal on that subject would be limited to plain error. And that probably means that an appeal here would be very unlikely to succeed. So that's what I have for you, just kind of post-morteming the Farris jury. I think they reached the right result. I think they obviously were able to work through some of the glitches or omissions in the evidence. And I would encourage you all to go to Court TV and watch Juror Bethany talk about this case. I think it's worth your time, if you're interested in this case, to hear what the jurors thought. At any rate, like I said, that's all I have for you today. Thank you for being here. If you have the opportunity, do something nice for somebody. Thanks for being here. Come on back tomorrow. Join me down here at the beach. We'll talk about something else. I shouldn't have to say this, but you don't seek legal advice from a guy down at the beach. You seek it from a lawyer in a lawyer's office, where there are people running around in suits and secretaries and all kinds of other people. I'm just a YouTuber. I'm a retired attorney at this point, and although I retain my license to practice in the state of Missouri, I am not here dispensing legal advice. I'm just offering general content on the law. And here are some videos that YouTube thinks you may enjoy.